I've been waiting for this panel all day, and the reason why is because you have three stellar panelists, and I'm anxious to hear their remarks about this topic. The topic is Worksite Criminal Cases, and the moderator is no stranger to the national audience. Sharon Melman is a co-managing partner of Larrabee, Melman, Albee & Coker in San Diego. Sharon's focus is on employment-based immigration for the tech industry. She and her firm are historically active in the I-9 compliance arena. Sharon has worked in I-9 external audits, training sessions, and ICE worksite enforcement matters. We know her to be a frequent speaker nationally in immigration topics and one of our most active members of the bar. Wendy Padilla-Madden is an attorney with Balch & Bingham and practices in the Labor and Employment Group. Wendy is a well-known immigration practitioner who focuses on business immigration, and she says about 70% of her time is devoted to immigration compliance of large and medium employers. I've heard her speak recently. She's just a riveting speaker, and apparently Ayla agrees. She's a new member of Ayla's Verification and Documentation Committee. The next person to introduce to you is Tina Shocketti. Ms. Shocketti is Assistant United States Attorney in the Northern District of New York, where she's been a prosecutor for the last 12 years. She is a nationally known prosecutor and is the lead prosecutor in the IFCO prosecution that's from the inception, from 2006 until the present. And I'm told that the IFCO criminal case is set to begin in September of this year in Houston, Texas. Ms. Shocketti is well known for her masterful negotiation of the non-prosecution agreement with IFCO, and those of us who have studied the matter realize that it was cutting edge and it is a national model for white-collar immigration prosecutions. So I give you our moderator, Sharon Melman.
Thanks, Chuck, and thanks everyone for coming back from lunch and joining us today regarding criminal matters in enforcement. I did want to start off by just stressing one important issue, and I think Dan really touched on this in his talk, and that is that companies for a very long time have not made I-9 issues a priority. It really hasn't been their fault because the government has not made it a priority either. They have not put resources into it, and so a lot of companies have said, you know, why do we need to worry about this? They took a risk assessment and they determined it was not worth their time and resources to really focus on it. As Dan joked around, they said, well, if we're not a hotel, if we're not in the food business, if we're not in certain industries, we really didn't need to focus on this. Well, as Dan mentioned, and as many of us who are practicing know, every company out there is a potential target, and every industry is a potential target. So it's so important right now that everyone focus on I-9s, and not only the fines, which is what we used to see, but also the criminal implications, which is what this panel is really going to focus on. And so first, I wanted to ask Wendy, what are some of the trends that you're seeing with your clients or in your practice where you've seen criminal immigration matters?
Well, first of all, thank you to Dan and Marcin for the invitation to come and be able to speak to you today. I will tell you that the things that I've seen, first of all, is a departure from investigations, whether they're civil or criminal, that are industry specific. You know, historically, the targets have been the construction industry, manufacturing, or poultry, or meat processors like I know Tina's going to be talking about a little bit, to really broaden out to all sorts of employers. We also have seen a departure from a target of those employers that are involved just in critical infrastructure or federal contractors. The other thing that I have seen is that now smaller employers are also a target of criminal prosecutions, whereas before those large operations might have been, or all those resources might have been devoted to just larger cases or operations like the big raids that we saw during the Bush administration. So I'm seeing that. The other trend that I'm seeing is a lot more intra-agency cooperation, and especially more cooperation between federal and state entities, where you might have something that begins as an audit for insurance practices by a state by state entity, and then there's some crossover talk, and then soon enough begins the federal investigation. So I'm seeing those types of trends change a little bit of the landscape of enforcement.
And I think that point, Wendy, is very important. For those of you who have only seen a notice of inspection and that was it and it ended it, great. But I think what a lot of companies and attorneys are seeing is, coincidentally, you have an NOI, and then all of a sudden there is an audit by Department of Labor wage and hour, and then there may be another agency that comes in, or it may start with one of those agencies and all of a sudden lead to an NOI. So not only is I-9 compliance very important, but I think that all companies should take this opportunity to make sure that they're compliant in all aspects of their businesses. As Dan mentioned, we have SEC issues, but we're really seeing, as Wendy mentioned, a lot of state issues as well.
And Sharon, if I might add something, I would say also that the other trend that I see is politics. You know, as our national dialogue becomes so polarized and it's so critical, and it's taking, you hear a lot of the pundits off with their heads talk about the employers, making the employers really the scapegoat for fixing the broken immigration system that we have. We're going to see a lot more pressure being placed both on special agents and on U.S. attorneys or other type of state enforcement to really undertake a massive cleanup, if you want to call it that, of the landscape of employers, and ensure in that way that you do have a climate of compliance, similar to what you would have in the IRS context. By and large, most employers pay their taxes because they know sooner or later the IRS will come calling. So, and I've heard this from the top leadership at ICE, that's what they would like to see in terms of enforcement compliance, knowing that if you do not comply with the immigration laws, not only are you going to face stiff penalties, but there will also be criminal charges and jail time.
We're very happy to have Tina on our panel today. And Tina, I wanted to ask you, in the past we always just saw fines. And are these criminal matters that we're hearing about, are they arising out of a civil matter, or are these just arising on their own? Where do these criminal charges come from?
Well, typically, there are a number of ways that we see criminal cases. And I guess I just wanted to give a little bit of background about what a U.S. Attorney's Office is for people who are not that familiar with federal criminal law. But essentially, there are 94 U.S. Attorney's Offices. Here in the state of California, the state is carved up into 4 of them. Arizona, for example, has just 1 U.S. Attorney's Office. But any federal crime occurring within that jurisdiction would go to that particular office. It's headed by the Department of Justice in Washington. Eric Holder is the current Attorney General. And so our function is essentially to prosecute federal crimes that are on the books. The way we found out about these, what we call worksite enforcement cases, are through a number of mechanisms. Most often, I see that it comes from disgruntled workers. So you have a former employee who wants to put a call into immigration about what's going on back at the plant, or a current employee who feels that there's some sort of favorable treatment of the undocumented workers. They get to get paid in cash, and my check comes with the taxes taken out, and it's just not fair. They're making a lot more money than I am. So you might get a call into ICE that way. Sometimes the cases arise from a media story. There was a case in Texas called Republic Waste Services that came when an employee reported that there was illegal dumping being committed by the company, and also there were a bunch of unauthorized workers at the work site. And that would spur ICE's interest or the U.S. Attorney's interest, and they may say to immigration, can you look at that situation? Sometimes it arises out of a civil suit, so that there was a spate of these RICO suits where competitors were suing each other, saying this guy had an unfair business advantage because he had a workforce of undocumented workers, and I couldn't get that bid. Or unions, you know, in upstate New York, we're a big union state. And immigration gets a lot of calls from unions who are not happy about losing contracts to companies that come up from North Carolina or somewhere in the South that use contractors to employ their, you know, to staff their workers. So there are a number of ways we get them. I tend to think that if there is an administrative investigation, depending on the scale of that, as a prosecutor, we tend to think that the issue is being addressed through that mechanism. And if the administrative remedy is sufficient, we will not bring a criminal case. But if it's an administrative sanction that, or investigation that shows just the tip of the iceberg, that could be another way that we get a case.
And are the ICE agents encouraged to work with the U.S. attorneys or the Office of Chief Counsel early in the process to determine whether or not to go forward on a criminal matter?
Absolutely. I think that has been the trend out of headquarters in ICE, to go to the prosecutor's office early, look at your options, but essentially the best criminal investigations are conducted with the agencies and the lawyers working together from the beginning, so that you could sort of issue spot problems if you're trying to put together a criminal case in the long run.
Thanks. Tina, now I'd like to move on, and I'm not sure that everyone's aware of how something that we consider to be paperwork, the I-9, or that our clients all consider to be paperwork, could turn into a criminal matter, and what some of those criminal charges may be. So can you let us know a little bit about some of the types of criminal charges that could be levied against an employer, and what some examples are? Because I think sometimes when we hear these words, I've seen press releases talking about, you know, harboring or smuggling, and I think, wait, that's a tech company. How could they have that type of charge? So what can you tell us about some of these charges arising out of worksite enforcement?
Sure. In an employment situation, there are all sorts of potential federal criminal statutes that apply. And I'll mention some of them, but essentially the core statutes that we have when you're dealing with undocumented workers on a workforce are these smuggling statutes under Section 1324A, and those include harboring illegal aliens, encouraging and inducing illegal aliens to enter and reside in the United States, transporting undocumented workers, or the statute uses the term illegal aliens, so I'll use that term, transporting illegal aliens in furtherance of their illegal stay in the United States, and bringing aliens into the United States at a place other than a port of entry. These are the core immigration statutes that you would use against an individual smuggler, for example, but they have been used against corporations that hire and employ undocumented workers. Each of those four ways of encouraging and inducing aliens to remain in the United States, transporting them, harboring them, or bringing them into the country, expose a company to 10 years imprisonment. You can't imprison a corporation, and we'll talk about this more in the next panel, but the employees conducting that conduct on behalf of the corporation are exposed to up to 10 years imprisonment, generally. There are some enhancements if the workers die during the course of the transportation or during the course of the employment, but generally it's a 10-year felony. The other statutes that apply, there's a specific statute in 1324A that was added later that makes it unlawful to employ 10 unauthorized aliens within 12 months. That statute requires actual knowledge, and so you typically see that prosecutors will use the first statutes that we talked about because the mental state, which is what we have to prove beyond a reasonable doubt, is a lower standard. It's a reckless disregard. And that essentially means being aware of facts and circumstances that let you know that a person is illegally in the United States and ignoring those facts and circumstances, as opposed to actually knowing that the person's an illegal alien. The final statute that is usually used in an employment context is this misdemeanor statute. And most of the panelists have talked about this morning under 1324A, where there is a pattern or practice of knowingly employing unauthorized aliens. You can be exposed to a prison term of up to 6 months or $3,000 per alien. So those are our key statutes.
Well, and Tina, can we talk about some specifics, again, how this would come up in an employment context? Do I need to be concerned if a big section of my workforce maybe receives paper checks and the other part of my workforce wants direct deposit, or if a big section of my workforce may have asked for my assistance to help rent an apartment, or anything like that? Sometimes HR staff is very helpful and they want to do what they can do to assist employees. Is any of this going to be deemed constructive knowledge, or is it even an issue for ICE?
It is. I think it's important to know that under the criminal cases, employment alone is not enough to prove a felony harboring or encouraging and inducing offense. So what we look at is what you knew and what you did. And the knowledge, again, we have actual knowledge, reckless disregard, something called, you're allowed to prove knowledge through a conscious avoidance theory, which is essentially, the HR person who puts the blinders on, and there are all sorts of indications coming at them screaming, illegal alien, and they're the ostrich who puts the head in the sand. They don't find out about it. They ignore all of these facts. You are not allowed to escape the consequences of your actions by ignoring those facts and circumstances. So you need employment and you need something else to constitute harboring or encouraging and inducing. And things like that will include offers of housing, providing housing, intervening with third parties like landlords and banks so that houses, the workers can get someplace to live, maybe paying the rent, helping them cash their checks, driving them to and from work, providing them with documents, telling them where they can buy fake documents, all sorts of actions that encourage and allow the worker to remain in the United States illegally.
And do we need to be concerned about conspiracy charges? Is there ever a possibility that someone could be charged with conspiracy in a workforce enforcement action?
The conspiracy and the statutes criminalize not only a conspiracy to do these things that we've talked about, but also aiding and abetting, which is helping the principal actor achieve the objective. And you can be held responsible as a conspirator without ever taking an act yourself, without ever doing what we call an overt act yourself. As long as you know about the criminal nature of the enterprise and you willfully join it and knowingly join it, you are as responsible as the people there who are doing the hiring, doing the transporting, doing the driving back and forth.
Okay. I know you have a lot to talk about. I'm going to jump to Wendy for a second regarding some state criminal issues, and then we'll go back and continue with some of the federal ones. Wendy, I know that you've had some experience where there were some state criminal law issues that arose.
As you all know, I mean, a lot of the states are, passing immigration laws that are similar to Arizona enacted. And one of the things that I'm seeing is in states like Alabama, which, our legislation just cleared the House and Senate. The governor has not signed it, but it's expected to sign the legislation. One of the provisions in that legislation is that it criminalizes, or it really expanded and broadened the definition of aiding and abetting to include entering into a contract with an illegal alien if doing so aided and abetted that person for staying illegally in the United States. And the question that we posed to the legislature was, well, what are you envisioning, when drafting this provision? And the answer was, well, we're looking at tax preparers, because obviously they have knowledge if they're preparing taxes or asking for taxpayer ID numbers. In the Alabama legislation, there is no exception for immigration attorneys. So if, for example, you are taking one of your clients to immigration court because they do not have a driver's license and they have a hearing, then you could be considered guilty of transporting them across state lines, and you could face up to a year in jail. So you also, I think, as an employer, have to be mindful of getting roped not only into a federal type of investigation, but now you have to deal with a patchwork of immigration laws that could criminalize some of the behavior that you have as an employer.
Thanks, Wendy. Just when we think we've got it all taken care of at the federal level, we have to figure out what every state is up to as well.
Yes.
And even if you don't have business in Alabama, there's several states, as she mentioned, that are proposing or have already passed similar statutes. Tina, let's go back to you about some other ways that employers could be criminally charged.
Sure. These are some examples of other ways to charge employers. And Dan mentioned earlier that, when you're talking about plaintiffs, securities lawyers, they can be very creative. And I have found that my colleagues can also be very creative in how to approach these criminal immigration matters. There are document fraud statutes that prohibit misuse of immigration documents, misuse of identity documents, identity theft statutes that have been used. You could be charged with aiding and abetting an employee's claim to be a citizen of the United States. If your employee is illegally submitting wage information to the IRS and SSA, I have charged and seen charged managers and executives who conspired to defraud the United States in that way, to conspire to interfere with SSA's lawful functions. As was mentioned, every I-9 contains a sworn attestation, false written statements to the government. We talked about obstruction of justice in connection with maintaining and destroying I-9s after you learn about ICE's administrative audit. Do you pick up the phone and tell your client, well, actually, if you did it, there might be an advice of counsel defense, but does your client rip up all the bad I-9s? There's some potential for obstruction of justice.
Tina, before you go forward, you were talking about that attestation. So if we are doing a proactive audit of a client's I-9s and they've signed at the bottom that they certify that they saw the original documents, but attached is a photocopy of the documents that clearly have been faxed, and the employee wrote at the top, here's a fax of my documents so you can fill out the I-9 form. I think we've all seen that at least once. Is that a concern about false statements?
Well, it is, although I think as with any area of law enforcement, there is a wide range of discretion that is applied in selecting which cases you're going to present to a grand jury or charge by information. And you look at the materiality of the false information, the importance of the act by the employer. And I mean, I would wager to guess something like that would never be prosecuted. Now, if every single I-9 was fraudulently signed or knowingly falsified that attestation, you're moving along the scale to potential prosecution. There are the usual statutes we use against in any financial or employer case involving money laundering. That's basically taking money earned through unlawful purposes. Specified unlawful activities is the term in the statute. The immigration statutes that I covered with you, harboring illegal aliens, those are specified unlawful activities under the money laundering statute. So if you take money earned that way and then you wash it through financial transactions, the corporation could be subjected to money laundering charges. Bank, mail, and wire fraud, pretty obvious federal statutes, I think, if you use the internet email that goes across state lines in connection with a scheme to defraud.
And actually, if I can jump in there, even though this is not completely related to I-9s, those of you who are not aware that the mail fraud and wire fraud is being used with immigration violations, definitely take a look at some of the recent actions. We often mail petitions to the Immigration Service. We're using the internet, as Tina mentioned, and these charges of wire and mail fraud have been used in a lot of the recent actions against employers with immigration violations.
Alien smuggling is under 1324. I didn't mention it earlier, but that's sort of when you have an employer who's making a concerted effort to bring people in from outside the country, knowing that they are not supposed to come into the country, they don't have authorization. That subjects an individual to a 3-year mandatory minimum if it's done for commercial advantage or private financial gain. I mentioned the human trafficking statutes that apply. I'm going to guess that no one in this room works with an employer who does things like importing aliens for immoral purposes or forced labor. But there can be some creative arguments made about involuntary servitude, making the employees work off or work for a certain amount of time for free until they finally get paid. These statutes have some pretty strict elements, and they're meant for really egregious behavior. The penalties are very high, but they potentially apply in an unlawful employment situation. And then I just wrote up there RICO. You can bring a RICO charge, given that these immigration statutes, again, or money laundering, or a number of these crimes that we've talked about are predicate offenses under the RICO law. And there is a potential civil RICO suit and a potential criminal RICO charge. And the penalties are just astronomical. The fines are triple damages, things like that. So,
thank you. Wendy, can you explain to everyone, right before the panel started, we gave them some handouts. Can you just explain briefly what's in the handouts and how that relates a little bit to what we just discussed?
Sure. The first handout is a fact sheet put out by ICE in April of 2009, basically detailing the shift of their worksite enforcement strategy. And if you go to the first page and the fourth bullet, it clearly states that effective of that date, ICE will focus its resources in the worksite enforcement program on the criminal prosecution of employers who knowingly hire illegal workers in order to target the root cause of illegal immigration. I think ICE has realized that A, they have limited resources, so they need to target them effectively, and 2, the deterrent factor of criminal prosecution, along with the associated press releases and the news impact out of those, is going to have a much higher deterrent factor than a minimal fine assessment. So I think that that it's something that can give us an insight into what ICE is thinking and how they're approaching this. The second handout is just 3 pages. I went through the ICE website in their news releases, and as you can see, they have posted news releases of over 70 investigations that they have handled since 2009 to the present, and all of these deal with criminal matters. Some large employers, a lot of others are just small employers. So you can see also the changing in the spectrum of what are the entities or the type of companies that are being targeted. So we thought that you would like that information.
Well, I think, and the charges. And the other thing I think that's very important, and it's something that I discuss with my clients all the time, when they say, what's the risk, and, maybe there's only going to be a little fine. If clients are not concerned about the fines, and they're, for whatever reason, not concerned about the criminal penalties, what they're usually concerned about, especially if they're a public company, is the bad publicity. And as this chart shows, ICE loves to issue press releases, and then it hits the papers. And Tina can mention this as well if she has an opinion on it, but really that's usually the biggest deterrent. Clients do not want to be seen in the news. And sometimes the client gets over it. People are still buying donuts from Krispy Kreme, even though they were hit with I-9 violations. But usually a company's competitors will go after this. They can lose contracts over it. They can lose employees. It's really an embarrassment.
So I agree, most employers, at least the ones that I deal with, they do want to comply. It's often difficult to figure out what to put on the I-9, when to put it, and where to put it. But assuming that we have employers who are trying to comply in light of all these criminal or potential criminal liability and civil liability, if my employer came to me and said, okay, I give in, I'll sign up for EVerify, it may not be free, but it seems better than exposure to criminal or civil penalties, will that fix my problem?
No.
What will my answer be?
No. First and most importantly, unless you're a government contractor, you could only put in new hires in EVerify, and unless some of the proposed laws that are always being introduced in Congress change that, that doesn't help you for your current workforce. So there's nothing that you can do there. Also, there's no safe harbor just because the employer is in EVerify. So the odds are that employers in EVerify should not have issues, but there are some loopholes and problems with the current EVerify system and the way that fraudulent documents exist out in the world, that things do get through EVerify. My recommendation to any client that says, I'm trying to do my best, what can I do, is to do a little of everything that was discussed this morning. Consider image, consider EVerify, consider putting together a comprehensive compliance program, bring in an experienced attorney to review I-9 forms, give trainings to your staff, keep notes of all of the actions that you've taken to try to become compliant, what trainings everyone went through, have written policies about what your I-9 program is. I know a lot of this is in the book discussed this morning. But take every step that you can take so that if there are problems later, there should be a good faith defense, and there should not be these pattern or practice violations. And hopefully, if there's an issue later, you can say, yeah, that was in the past. We realized we made a mistake, but once we sought assistance, then going forward, you can see that we corrected these issues. But I don't think there's anything out there that will make you 100% safe. What we want to do is try to encourage employers to at least take it seriously and try the best that they can. I think that even though employers say they try the best that they can, what you notice is it isn't always a priority, and it's that same mistake over and over and over. And sometimes that same mistake is a paperwork violation, and sometimes that same mistake over and over and over becomes a pattern or practice.
I'll piggyback on something that Dan mentioned in his panel when he said that somebody in law enforcement, or somebody had mentioned that technology had been the biggest gift to law enforcement. I will say that EVerify is probably going to be, following right in those footsteps, and that we have seriously underestimated what EVerify is going to do to the world of worksite compliance. And first of all, if you go look at the disclosure notices of EVerify, that data is going to be held by the government for a minimum of 10 years. So even though you might not be required to keep that I-9, 3 years after date of hire, 1 year after termination or longer, but if you're an EVerify employer, that data is still there. And also the other thing that I've seen with EVerify is that it really puts a premium on the value of a stolen identity. So it really shifts, how a bad actor can impact your company, because you can have somebody that out of sympathy or out of pure greed, they decide that they're going to game the system. And unless you as an employer have a very well-established compliance program that takes into consideration not only the EVerify portion, but also the I-9, then you can have an employee that is really going to throw in a monkey wrench into the whole system. And when you're being looked at with the eyes of a prosecutor or a special agent, they're going to see bad faith. And that's probably going to be the startup of a criminal investigation. So I don't think that EVerify is the solution to our immigration problem. I think it's a part of it, but I also think it's going to have a much bigger impact in this arena than we expect. It is not a benign program as it is being touted, in my opinion.
I hate to disagree with my learned panelist, but I have to say that as a federal criminal prosecutor, I have a different opinion. And again, they speak to sort of the day-to-day challenges of their corporate clients. If you're asking how is ICE or a criminal prosecutor going to look at a corporation's behavior, a favorable factor will be the fact that you participated in EVerify. It's what ICE is touting, it's what they're asking you to do, you're doing what the government is asking you to do. And one of the major considerations on whether or not you charge a corporation is their compliance program, their good faith efforts before the criminal conduct was discovered or took place. And if you are an employer in today's day and age and you participate in EVerify, it's going to be a major consideration for both the agency that investigates the crimes and the agency that prosecutes them. So, there are pros and cons.
I hope all of our ICE agents and U.S. attorneys out there are as learned as you
Yes.
are. I really hope
Yeah.
so.
I mean, we don't disagree. I think the issue is just that there is no guarantee. But I
It's
think
definitely
that it
not a
can definitely help.
guarantee. That is absolutely true. Even the best compliance program, state-of-the-art, every bell and whistle will not necessarily protect you from a federal criminal charge or a state criminal charge. It's relevant in terms of the considerations of whether or not you indict a corporation or its employees, whether or not you go with the administrative or civil sanctions, but it does not there's nothing that's a safe harbor. Nothing insulates you, but it is certainly a factor that we take into consideration in determining whether or not to prosecute someone.
I wanted to comment on something Wendy just mentioned because it's something that I've experienced with some of my cases, and that is that evidence is viewed in the eye of the beholder. And what we see as good faith and what our clients may see as good faith is not always seen as good faith by ICE. And so it's important that you take a look at how would an agent or how would a prosecutor look at this. And it's been very interesting to me to see how some things can be turned completely on their head when I thought this clearly shows good faith. And look at all the efforts I took. And in fact, ICE said, no, actually, we think that shows evidence of a criminal act, or that could show evidence of bad faith.
I can give you one
Yeah.
that is really visual. I was talking to an ICE agent who was intent on stating that my client knew that 5 of their employees were illegal aliens because the fingerprint on the permanent resident card was exactly the same. And I kept telling them, well, you have the benefit of seeing these as a whole packet. I mean, you have all the I-9s and you're looking at them. But we had to go in and, all these hires happened at different times. And we had 2 different hiring agents for that employer who did the hiring. So you're not there, looking at, okay, I'm gonna memorize your fingerprint so that 2 weeks from now, when somebody else walks in with a card that has a similar fingerprint or the same fingerprint, you're gonna remember it and say, you must be illegal. And so, but that I think, exemplifies how they're looking at it, where you as an employer might not recognize a particular pattern, but in a different context, and because they're seeing the data in a different way, it makes totally different sense to them. And my question has always been is, how is a jury going to interpret it if you're in a criminal investigation? Because ultimately, it's they're the ones that are going to be making the determination of, was your assumption reasonable, or should you have reasonably known? The prosecutor is going to present their case, but it's the jury that's going to make the decision. If they see those 5, permanent resident cards all with a matching fingerprint, are they going to go, aha, yeah, they should have known? And then
Yeah, I have another
Get used to
example,
that.
and something was mentioned similar to this morning. So the SSA no-match letters, they have not been issued for many years. They say on their face, so they're not proof that somebody is unauthorized. But most of the administrative subpoenas by ICE that accompany an I-9 audit request copies of all correspondence from SSA. And the no-match letters, many of them actually say on the top, do not copy. It's the position of SSA that there is no retention requirement. And so employers in the past, when they weren't required to keep them, got rid of them. After a certain number of years, they misplaced them, they're just gone. So you have an I-9 audit, and the agent asks, did you ever receive a no-match letter? And we say yes, but we don't know where they are. We remember getting them in the past. We just don't have them. We didn't keep them. And in our mind, okay, we've showed good faith. We provided the info. There's no legal requirement. To someone else, that can be viewed, and it was asked whether or not, in fact, maybe this was evidence of conspiracy or obstruction, that maybe we purposely got rid of them, and maybe the fact that we got rid of them may mean that we had knowledge that somebody was undocumented, or maybe we did, they did show evidence that someone was undocumented. It's just a way that something can be completely spun in a different way. And again, I just found it really interesting. It's important that everyone remember that each government agency doesn't always agree with each other. We were all debating this morning about SSNVS. The first session was talking about the Social Security verification service and whether or not, what ICE thinks about that and whether or not that's a good idea or bad idea. This is a little off topic, but it's just interesting that in a lot of these panels, each of these groups has a different opinion on what you should do. So I think it's very important, and Dan mentioned this, that all of us really need to keep up, not only on one particular fact, but everything that's been going on in the news regarding worksite enforcement and employer sanctions.
Tina, do you have an opinion on retention?
Yeah, I would not ever accept the case that Wendy talked about with the fingerprints. I'll say that. And I sort of encourage listening to these stories. And I guess in the past day, talking with these incredible women that I've met, I've encouraged them. I have a supervisor. That person has a supervisor on up to the U.S. Attorney, on to the Department of Justice, and ICE is the same way. And if you are representing an employer and you believe in earnest that what that particular ICE agent is telling you just doesn't seem right, go to his or her group supervisor or his SAC or write to Washington. I know it costs money and the clients may just want to settle it, but I definitely have a different view about Social Security no-match letters and what they mean. I know what the law is very clearly, and you all know that. But I could see that, you know, if there's evidence that they were destroyed, that would be an indication of some sort of conspiracy to hide the problem. But if there's no evidence of that and they're simply not retained, you know, you couldn't draw that inference. Ultimately, we have to prove the case beyond a reasonable doubt. And if you hold up 5 fingerprints and say the person should have known over the course of 3 weeks that those were the same fingerprints, you're just not going to do it. So, but I do have a different view even within the confines of the Social Security letters, and I've interviewed the people who issue them in Baltimore. The letters don't tell you not to do anything. They don't tell you just read the letter and throw it away. There are very specific things you're allowed to do, but they don't say ignore me. And so I think that's one of the factors. That's how those letters have come into play in these cases. The employers have received them. The employers have simply done nothing, or they've not followed the instructions in the letters, or they get them year after year after year after year and do nothing to fix the problem with SSA or to look at the hiring practices. That's how those come into play.
And I will say this. I heard a comment from a very incredible, also female attorney called Eileen Schofield, and she mentioned in one panel, she said something that, it really captured my attention. And what she said was that employers should treat these no-match letters and all these other discrepancy notice as the lap dance. And, what she said is, what happens if an employee walks into the HR office and tells his HR manager, my boss wants me to give him a lap dance? There's immediate surprise. Somebody jumps to action. Somebody actually moves. And that there should be a similar response when an employer gets a no-match letter, when they get a phone call saying, you know what, my ex who's working for you, he's really undocumented. Or when you have someone else calls in the tip line that the company has set up and say, we have 300, out of the 300 employees that are on the night shift, I know that there's 40 that are undocumented. And so you should treat that with the same level of urgency so that you can demonstrate, and I believe what she said is that she helps her clients develop a tickler for what is the response within 10 days of that initial notice. So what did you do, employer, to make sure that you responded? And I think in the case of a no-match letter, the issue is not necessarily did you keep the no-match letter or not, but the issue is did you resolve the discrepancy, and what steps did you take to resolve the discrepancy, and did you document that? If what you found at the end of it was that employer was not authorized, was he terminated, is it notated somewhere in your, compliance binder or something?
Absolutely, and some of that is kind of beyond the scope of this panel, but it's just something that we wanted to raise. Did you have a quick question?
Just a follow-up question to the no-match letter issue in totality. You have the directions where they recommend that you have the employee take care of it with the Social Security agency. The employee does try to do that in good faith, but as time goes on, you keep asking the employee says, I'm doing what I can. What happens where it goes to like 90 days, 120 days, and should I terminate? Because the Social Security no-match letter in itself does not state that this person is unauthorized.
I think that what you have to do there is a complete assessment of the entity. What type of company it is, what is the makeup of your employees, what is your jurisdiction, who is your U.S. attorney, who's going to be your ICE agent. I mean, there's a lot of factors that would play into that, and then set a standard operating practice for how you're going to deal with all these discrepancy notices, including the no-match letter, and stick to it. And whether it's going to be, if you do not have resolution in 30 days or 60 days or 90 days, whichever. And obviously, the guidance that was rescinded, it clearly can provide a good roadmap that you can use to set up your standard operating practice.
And that's what we use. I mean, there haven't been regulations, there haven't been rules, but what was laid out in the proposed guidance is a good matrix to follow.
And I've told my clients that as well, but the thing is you have some clients who state that, well, I-9 the person, everything looks fine. I shouldn't even be able to terminate the situation.
But that's where the criminal side comes in, because then you have constructive knowledge if you just ignore it.
But they're not ignoring it, and that's what I'm saying. And I'm interested to get your feedback on
Well,
something.
what I would say to you is I learned from SSA that there are a whole slew of people who are paid to answer your question. They have people who work with employers and help them through that entire process of resolving the Social Security numbers that are sitting on their suspense file. And I was sort of reminded of this earlier when we had the discussion about the anti-discrimination procedures. There's an entire section at the Department of Justice in the Civil Rights section that is there as a resource to you as employers and lawyers if you want to set up a hiring procedure that is non-discriminatory. They're thrilled to work with you on that and thrilled to give you tips on how to do it. So I would just say call SSA.
And with SSA is one thing, but of course, if you talk about the discrimination aspects of it as well, when we try to get Office of Special Counsel's view of things, things are all over the place. And that's the reason I just wanted to see if there's some clarity in it.
Though in my experience, OSC has been great too, to call on the phone, ask questions. You can't always get it in writing, but I document it very well, who I spoke to, and they have been very good about giving their opinion on a lot of I-9 and EVerify related issues.
And they give you their names.
Yeah. So I think we've already started covering this, but either Tina or Wendy, what are some other triggers that may prompt an administrative issue to become a criminal issue?
I think, we sort of look at one of the factors we consider is the nature of the offense. How widespread is it? How complicit are the managers in the behavior? I don't want to step on my next panel's talking points because they're going to kill me, but that'll sort of go to the factors that we evaluate in determining whether or not to prosecute a corporation. But, I just always think of the egregiousness of it. It's really a scale. On one end, you have no prosecution, administrative remedies, civil remedies, and on the other end, you have a federal criminal indictment. And there are a number of factors that I'll talk about in the next panel that you consider in doing that.
And I would say that what I see is what is the culture of the entity as a whole. I mean, and I think that those statements or those policy statements, if you want to call them, come all the way from the top. Is the whole culture of the company and the way that the policies and practices in the company have been set up so that you can allow some of your, lower management to kind of turn a blind eye and get away with it, because, yeah, we really do know that we have an issue with an illegal workforce but we really don't want to know it for sure, because then we would actually have to do something about it? Or do you really have a, message coming from the top that says we will strive for, the highest level of compliance that we can possibly achieve within the means of our company? Obviously they're going to be different depending on your size and what you do. And so I think that that's where it starts. And if you have, the first type of company and, you have upper management that kind of ignores it. And I've been in conference rooms where we've had the HR department pitted against the operations department, where the operation managers are given utmost deference by the top line of the company because they're the ones that gets things done, and HR is just seen as the damn nuisance. So get out of here. That's just paperwork. Just get out of here. I mean, I've got to get this done. I've got to get this built, or I've got, and so I think in that sense, because of the company culture, that breeds or allows for these bad actors to come in and do things like subvert the EVerify, have I-9s that are completed in one location, that is a FAR EVerify employer, for example, but then have the employee transfer to, from a non-EVerify FAR place to the other one so that they can subvert EVerify. I mean, they can become very creative, and I think that that's what can turn something into, pretty bad criminal case.
So Wendy, if I represent a company that has only U.S. workers or a majority of U.S. workers, do I even need to be concerned that anything could become criminal? I mean, a lot of the talk is always about unauthorized workers.
I think that your risk is less, but I also think that all special agents are, law enforcement agents. So they are looking at these not only through the eyes of a civil case, but also through the eyes or the possibility of a criminal case. And look, ultimately, even if that prosecution doesn't take place, the expense that you're going to go through to even just defending your position with ICE is going to be enormous. So,
in fact, one of the areas of prosecution I didn't mention, but this sort of raises it, in this area of the country, is these visa fraud cases you see with respect to the H-1N1 visas, and companies that are conspiring with immigration attorney, less savory immigration, less reputable immigration attorney, shall I say, but the HR managers there falsifying the information that's provided to get these H-1 visas issued for employees to come in and work. That's a common area of prosecution.
I think the visas are going to be an area that are going to turn or have the potential. I see, with large employers, the misuse of the visa waiver, where you have executives that are coming in who might eventually get an L visa or might, get another type of work visa, but before they can go through all the, getting the visa set up and everything, they bring him in for 30, 40 days on the visa waiver to actually perform work. Well, these are white-collar, top-level executives that are managing departments inside of corporation that are illegal workers. No matter what you want to call them, but they're engaged in gainful employment, and so I think that could also be an area that could create issues for large corporations where there's no illegal workers, or the typical illegal worker. You won't find them.
Just to summarize or understand the bright line test between civil and what rises to a criminal level, is it correct to state that where there is no intent, but nevertheless a very sloppy pattern and practice, that a pattern and practice without intent cannot rise to a criminal level? Is that correct?
We have to show intent, and then the only way the pattern and practice sort of comes in is with that misdemeanor statute, where you are, the statute says that you're knowingly hiring or continuing to employ unauthorized aliens. So we have the intent requirement of knowledge, but as I explained earlier, how many people here have had someone walk into their client and say, I'm an illegal alien, can I have a job here? Very rarely does that ever happen. So what we as prosecutors do is look at all of the circumstances that would let the employer know that this person was undocumented or an illegal alien under the statute. And knowledge can be, there's a term of constructive knowledge under that statute. So you could have the pattern in practice where you get the notices and you ignore them, and all sorts of things are coming in to tell you this person's undocumented and you ignore them. And that's sort of parallel to the criminal idea of reckless disregard or conscious avoidance. You know, we sort of talk about, in looking at these cases, employers who want to buy themselves plausible deniability. And that is, well, if I've got an I-9 in the file and I photocopied the IDs, I'm fine. And you're not fine. You know, I can't really talk about the IFCO case because it's pending, but there were I-9s in that case, there were documents in the file, and most of the cases that are coming with these large employers, they get I-9s, they fill out I-9s, but there's all sorts of indications that the workers are undocumented. So an I-9 is not going to buy you that plausible deniability anymore.
Well, I think that's important. You can just be sloppy on the I-9 and you know, the individual isn't checking the box in Section 1 on several of the forms, or what they're writing down or what documents they're providing to you is pretty clear. You would have actual or constructive knowledge that there's an issue and just nobody deals with it. Things could rise to a criminal matter. There are attestations, again, on that form. And so when you are signing it, you are saying that you've done certain things. I think this is where we're saying we need to get everybody focused. It doesn't only affect companies with undocumented workers. That may be the company that's more in the news, but it could affect anyone. Wendy, you spoke a little bit about what you see in the future. You and I have discussed this a lot, and maybe some other potential issues that could be civil or more likely criminal in the future. Where do you think ICE may be going in the future?
You know, I see a lot more intra-agency cooperation and sharing of data. I mean, I think that the electronic world, you know, it's something that they're rapidly approaching. I also think that there will be a, you know, significant increase into the electronic I-9 platforms. I see that as something that is going to come in the future. I think ICE has not yet caught up to that and doesn't yet, but they're gaining fast. I would say, you know, they're maybe about 6 months behind. You know, and this is something that is here to stay. I mean, with the opening of the new auditing center, you know, the expansion of ICE and, you know, the hiring that they've undertaken, and until we have some resolution on the comprehensive immigration type of reform, you know, this is an issue that is going to, you know, continue to be here.
And what about the reported large numbers of non-compliant EVerify employers in those states where EVerify is required? Is that something that you think we should be concerned about in the future?
I think so. I think you had mentioned yesterday that some study out of Arizona found that only about 15 or 20% of all Arizona employers are EVerify. And they've had that mandate on the books for some years now. So, you know, now we're seeing in Mississippi, for example, the Mississippi Employer Protection Act, you know, mandates EVerify. And as of now, every employer in Mississippi should be EVerifying. And I have represented many Mississippi corporations that come up to me and have come up to me this year saying, when am I supposed to do that again? And there's no enforcement mechanism in the bill. So, you know, also what I have heard is the SSA has said that they do not have the capability of dealing with all the discrepancy notices that would come out if there was nationwide, you know, EVerify, that if it was implemented for every employer, that it, you know, that it needs to be somewhat in a staggered manner to give them the time to build in the capability to deal with all the no-match, you know, issues that would come out of that.
Yeah, I also think this is going to be an issue for the future, and at least in California, it can be very difficult to determine who is subject to EVerify. Obviously, you have Arizona, the whole state is subject, but in California, a lot of very small cities and municipalities have determined that anyone who wants to have a business license is required to be an EVerify. Lancaster, California, very small city, Temecula, and all of a sudden you find out your client's in non-compliance and they don't even know about it. I think this is something that we should all focus on. It may not rise to a criminal matter right away, but I think it's something to focus on. Tina, are you able to talk at all about thoughts for the future?
Just, I think, you know, the way a federal prosecutor's office works is that the agents investigate cases and bring them to your attention for prosecution. And as long as this remains a priority for ICE, and it is a priority for ICE, they're going to bring the cases to us. So you're going to continue to see the cases. I know of a number of cases in the pipeline across the country, and it is not going away anytime soon.
You know, one other thing I wanted to ask you, and it's in one of the handouts, the fact sheet. We know that we're not seeing these massive raids anymore, but the fact sheet seems to say that of a lot of these arrests and enforcement matters, that a lot of them are against the employees rather than the employers. So do we need to be concerned about employees having criminal charges brought against them?
I don't know the fact sheet.
Oh, I'm sorry.
I don't think I've read
One
this
of the things it was just saying is that any comprehensive workforce enforcement strategy must address both employers who knowingly hire illegal aliens as well as the worker themselves. Of the more than 6,000 arrests related to worksite enforcement in 2008, only 135 were employers, which implies that the rest were employees.
Right. I think what that's probably referring to is the sorts of cases you see where they go in and charge the employees with document fraud or identity theft. I actually have seen that sort of prosecution waning, and I think, at least what I've read in the paper, is that ICE's focus is on the employers. I think the numbers would vary because usually you have one manager in a plant with 200 employees, and that's why there'd be far fewer employers. But the trend that I see is the focus on the employers and not charging the undocumented workers, but rather either processing them administratively, allowing them to return voluntarily, or because ICE is doing a lot more of these I-9 audits as a mechanism for investigation, the employer will get the notice of intent to audit, whatever the term is.
The NOI.
A request for the I-9s, and when they learn that the workers are undocumented, they let them go. So they're out before ICE even comes to talk to the employer again. But the focus is not on these raids, although I want to point out that it is our clear understanding that that is a permissible investigative technique. And so if you're in Houston, Texas, and the prosecutor in Houston, Texas investigating a particular case feels that the most effective way to investigate that case involves a nationwide raid, that is still permissible.
And I've seen them, you know, recently in some states in the South where raids have taken place.
Yeah, I tend to see
especially
in the
on federal
paper that they'll
contracts.
say that was a Bush administration policy and the Obama administration doesn't believe in raids. The word that the agents have gotten in ICE and that we have received as prosecutors is the widespread raid is an investigative tool that's open to you if you want to use it.
I did want to mention, because I know a lot of us, we deal with immigration, and now we're dealing with employer sanctions, but we're not criminal lawyers. All of these discussions are not meant to make any of us criminal lawyers. I think the most important thing you can take away from this is to know that if there's even a potential criminal issue that comes up, either when your client receives an NOI or if you're just going through and doing a proactive audit, that the first thing you do is you get a criminal lawyer involved. You have someone on speed dial who understands immigration. You don't want to just deal with any criminal lawyer out there who just always is going into court for DUIs and doesn't know anything about immigration. But there are a lot of attorneys out there who do both things or understand. You really want to get a good criminal attorney involved. And you also want to make sure that you bring them in early, because there could be different issues with conflict of interest and whether or not multiple criminal attorneys need to be brought in. I think the issue here, and I can't stress it enough, is to just get someone involved early and make sure your client is conferring with someone early. You don't want your client later on to say to you, how come you didn't even say this is a potential issue?
You know, and I would say that as an auditor, you know, and as you're beginning to advise clients, that is going to be one of your key success, or one of the things that you should really focus on, is learning when is the time to call that criminal attorney and how to hand over your case to them. Because not only can you, you know, damage a, you know, client significantly if you do not bring in that criminal lawyer, but you can also miss opportunities for, you know, lowering or dissolving the potential for a criminal investigation that, you know, you could have if you brought them early. You know, there's some attorneys who have white-collar criminal attorneys within their practices, and I think, you know, it would be well worth your time to educate them on immigration. If not, at least establish a relationship. Find out who are the white-collar criminal attorneys in your jurisdiction and try to establish some relationship with, you know, a couple of them, and educate them on what you're seeing, and find out who has, you know, good relationships with the U.S. attorney or with local prosecutors if you're dealing in a state like Alabama that is gonna, I believe, start enforcing criminally some immigration laws.
We have a few more minutes. Wendy, is there anything else that you'd like to add in summary that we haven't covered, and then I'll throw it to Tina?
I would say also, going back again on what Dan said, and this is just kind of a fun fact that I'll give to you. Earlier this year, there was a news, it was a local news station, and they did an undercover investigation of a local employer. They decided to send somebody in and start talking to the employees, and very quickly discovered that all the employees in this particular job site were illegal. And so 2 days later, I get an email from an HR manager that sends to me a chain of emails from within their organization. This is a different employer, where there is a link to that, you know, that news broadcast. And the caption on that email says, "Ha, that could have been us." And it goes viral within the company. About a week later, one of the job sites of that company gets raided. And, you know, how that can be used. So I think it's also important that you educate your workforce regarding communications about these types of sensitive issues.
Yeah, I think that's important what Dan said. I see a lot of employees in different companies saying a lot of things over email, and even a lot of HR sending questions over email that probably would be better on the phone, as Dan mentioned. I think that's a great point, but we've also seen a lot where once one company gets hit, even if it's with an NOI, that goes through the grapevine. Everybody knows about it. And if there's an NOI at one company and there was undocumented workers and they wind up leaving, all of a sudden they show up at other companies nearby, or if there's any actions, it really goes through the community. So it's important to remind your employees what to keep private.
Yeah, and we were discussing that the other day. I worked in a case in the East Coast, and in this case we were dealing with an employer that had some notice that they had, you know, maybe about 25 or more employees in their workforce that were undocumented, and we were dealing with that issue. And at the same time, a very geographically close competitor got audited, and they laid off maybe about, you know, 100 workers, so they terminated them in the context of that investigation. And we were trying to contact an employment agency to see if we could fill out some of the positions in there. And one of the things that we very quickly realized is that the employees that had been terminated at the competitor were now applying for jobs with us. So we had to, in the contract with that labor provider, say, you cannot place in our facility anybody that has just been terminated from so-and-so, nor can you also place anybody that has previously worked for us that we have terminated. So because we knew that the moment that we terminated our employees, it very well could be that they would go in and get a job there and then come back to us. So, and I think that if you don't do things like that or not careful, then that could result in, the attention of somebody probably at ICE or, a U.S. attorney.
Yeah, and that comes up not just with undocumented workers, but a lot of times if you don't pay attention, you could wind up hiring back employees through a temp agency. It's definitely important to make sure you have that covered. Tina, in the last few minutes, did you have anything in summary that you wanted to say about this before you go on to your next panel?
Just the importance of taking measures. I mean, I think dealing with companies, it's all about money in the end, right? They don't want to spend the money if they don't think it's worth it. And I wish I could bottle up Dan's speech and just play it to everyone who owns a company, because it is about money now, and it's about what it's going to cost you in the end. And the change from when I became a prosecutor 16 years ago and this sort of case, even criminal immigration cases in general, if you walked into a federal district court in most jurisdictions with an immigration case, the judge couldn't be ruder to you. You were just, why isn't this an immigration court? Why am I even dealing with this? And I think you all see now how acceptable the prosecutions are, the frequency with which they're occurring, and it is a firm part of a federal criminal practice now. There are some U.S. attorneys' offices across the country who specialize in it. If you're in Houston, you better have your stuff in order, because the guys there, and they're all guys, know it inside and out. ICE is very aggressive in Houston. And it sort of, we talked a little bit about the different priorities with within ICE and the different cities, but you just never know. What I would tell a client is you never know when it's going to be you. And so you better have a compliance program in place. You never know when your disgruntled employee is going to turn you in, or your ex-wife, or your girlfriend on the side. You never know. So get your program in place. That's all.
Great. Well, if we don't have any other questions, then we will conclude. So thank you.